We're going to talk about the substitute trustee and when they are a debt collector. And I'm basically just going to go in and discuss another case with you guys so you get the clear understanding. I've been saying it all along. We have a lot of our members that are in non-judicial states, and they got to go in for injunctions and et cetera, et cetera. So I've always said, guys, strike first, strike when the iron's hot. If you have all your facts and your ducks in a row, if you set these people up from the beginning, you can take them into a federal court, not a circuit court or like a Supreme Court, like in New York, which is Supreme Court's nothing but just a circuit court with a fancy name. You're going to have a lot more leverage up there. And every one of these guys is violating some sort of federal law, and that's why I say go to the district courts, because even the circuit courts down below, they don't like to acknowledge for some reason the federal. I don't know why these judges are so closed-minded to it. I really don't. But at the end of the day, it's always better just to go up there. It's a bigger, it's a ballroom. It's not bigger. It's just a ballroom dance versus a discotheque down below. The rubber stamps for the banks are below, and you might have a fair shot up above. So anyway, with that being said, when is a substitute trustee a debt collector? Well, you got to read Wilson versus Draper and Goldberg. Draper wrote to Mrs. Wilson to advise her that she was in default on her loan, and that Draper was preparing to commence foreclosure proceedings. In its correspondence, Draper advised Wilson that federal law requires us to advise you that this letter is written pursuant to the provisions of the Fair Debt Collection Practices Act, and that the letter was an attempt to collect a debt. So generally what's going to happen is you're going to get a letter from the attorney in your non-judicial state, or you're going to get a notice of sale. It depends on how they want to bypass their responsibilities. But generally, you're supposed to get a letter from the attorney, and then you're going to get the notice of sale stuck on your door sometime there shortly after. So Draper also sent Wilson a validation of debt notice as required by the law, but stated in the notice that Draper was not a debt collector and that it was not acting in connection with the collection of the debt. What? Is a big question mark. How can you, on the letter, say, I'm going to start litigating, and I'm sending you this letter as pursuant to 15 U.S.C., right, the Fair Debt Collection Practices Act, and then in turn say, you have the right within 30 days to dispute the debt, yada, 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 as required by the Act. But then tell them that it's not a debt collector and I'm not acting in connection with the collection of the debt. Are they crazy enough to actually put that down on paper? I can't ever get over the fact that they would do something like this. So Wilson disputed the debt and requested verification. As we always say, that's the first thing you should do. Shortly thereafter, being the smart attorneys that they are, Draper commenced the foreclosure proceedings. Wilson also retained counsel who advised Draper that all the communications regarding the dispute should be directly with him, so they don't go around counsel and violate the FDCPA. Nevertheless, Draper Sales Department subsequently wrote to Wilson directly to inform her of the date of the scheduled foreclosure sale. This letter included a statement that it was an attempt to collect a debt. Wilson's attorney responded by requesting a complete statement of her account, a response to which he sent directly to Wilson. Prior to the conclusion of the foreclosure, Wilson settled the underlying dispute with the lender. Of course they did. Now remember what they said. Wilson's attorney requested a complete statement of the account. And then they responded by sending it directly to her. That's the violation that they're talking about, going around counsel. Wilson brought suit in the U.S. District Court for the District of Maryland, claiming that Draper failed to validate her debt, or verify her debt, and it continued its collection effort after she had contested the debt and communicated with her directly after being notified that she was represented by counsel. Now listen, how many times have you heard of us all, Dave, Larry, myself, on our calls, and even for you new members, you're going to hear it over and over till you think it in your sleep, that once you sent the verification or the validation request, anything they do after that is considered a violation of the FDCPA. In this case here proves that. I don't care if you're a trustee, the attorney's firm, the servicer, it's irrelevant. Once I've disputed the debt, you better stop. And I've always said that here in Florida, it's worked. show up at the motion to dismiss hearing, they haven't verified or validated the debt, you just tell the judge this hearing cannot continue, they're in violation of federal law, and if you allow this to continue, it's going to be an unlawful hearing, and I'll have to include you as a defendant. I've got it on the record because I'm telling you you're allowing them to violate the debt. Whether you get away with it or not doesn't matter. The point is the judge understands you're not playing any games. And if you've listened again to our other key point is what? Have yourself a court reporter. It's all on the record. So that's very, very important. Anyway, Draper, of course, being the smart attorneys, again moved to dismiss, arguing that it was not acting in connection with the debt, and that even if it was collecting on a debt, Draper was exempt from the definition of debt collector because it was acting as in its role as a bona fide fiduciary. Remember what I said about that? Fiduciary responsibilities? That's it right there. A debt is a debt. So Draper argued that foreclosing on a deed of trust is not an enforcement of obligation to pay the debt, rather the termination of the debtor's equity of redemption in the property. Wow, what a nice argument that is. I'm not collecting any debt. I'm not asking for any money. I'm just taking their house. Wow, that's nice. So you understand now? This is what you're going to get back when you file. So that's why I wanted this case on our site for our members to look at it. It's very, very important. The language and the argument in here, okay, and what the appellate court came back with. The firm cited the case law supporting the argument that foreclosure on a deed of trust is different from a debt collection effort because the objective is to foreclose on the debtor's interest and not the payment of funds. Well, isn't that what every single foreclosure action is? It's an in rem action. I'm either suing you through the courts to foreclose on your home, or I'm foreclosing on your home through the deed of trust using a substitute trustee to still take your home. The end result is they're both in rem actions. I don't care which way you want to look at it. Look it up in the legal dictionary. In rem, R-E-M, means the thing. I'm after the thing. I don't want any payment. I don't foreclose you for payments. I foreclose on you to get the house back. That's the way it works. But there's even one more deficiency here. In a non-judicial state, if they take your property, correct? And they ask the judge in the final judgment when they got your property for any deficiencies down the road, now what's happened? They've just automatically turned themselves into a debt collector. And that's the other catch, which you're not going to hear about in this case, but I'm telling you that's the other catch. You cannot have an in rem, right, for the thing action and say it's not subject to the FDCPA because I'm not collecting payments, and then turn around and say, well, if we sell the house and there's money that's still owed because we didn't get what the house is worth, we want that money. You're asking for money now. You're not just asking for the house. You're asking for both. Now you're a debt collector. End of story. There's case history. You're blue in the face, but they never talk about it. They don't want everybody to find out about it. Anyway, although the trial court was persuaded, of course, the trial court, the U.S. Fourth Circuit Court of Appeals soundly, wow, I love the word soundly, rejected this argument, concluding that a debt remains a debt even after foreclosure proceedings commence. It's awesome. In rejecting Draper's position, the court expressed concern that if accepted, such an argument would create an enormous loophole in the act, no duh, immunizing any debt from coverage if that debt happened to be secured by real property interest, and foreclosure proceedings were used to collect the debt. Trustees and other fiduciaries can be debt collectors, but it must be argued correctly, guys. Draper also argued that even if the collection activities concerned a debt, it was exempt under that act because the firm was acting in its role as a fiduciary to the lender when it commenced the foreclosure proceedings. The court rejected this argument as well. Looking at the language of the exemption for bona fide fiduciaries, the Fourth Circuit reasoned that the critical inquiry is whether a trustee's actions are incidental to the bona fide fiduciary obligation. On the contrary here, the court concluded that Draper's foreclosure activities were central to its role as a fiduciary. Let me clear that up for you guys. I don't get that. If in fact I have fiduciary responsibilities of doing A, B, and C, and foreclosure happens to be F down on the list, then that might be reasoned as, well, they're incidental. I mean, I'm just doing it as part of my job. But when the foreclosure activities are central to the role, meaning my only role as a fiduciary is to foreclose, you're not getting out of that definition. That's very clear and distinct, and you need to understand the difference. I'm not doing this just because it's there and, oh, well, I'm doing so many other things. I'm doing it, and this is the only thing I'm doing. That's literally what the court has just said. Thus, to the extent Draper used the foreclosure process to collect Wilson's alleged debt, they cannot benefit from that exemption because that's all they're doing is collecting the debt. The court also dismissed the relevance of the fact that Draper was a law firm, finding it well established that lawyers can be debt collectors even if conducting litigation. Remember Hines versus Jenkins, guys? I always tell you, read, study. The court also noted that Draper instituted more than 2,300 foreclosure actions in Maryland in 2003 and rejected any claim that the law firm with such a volume of foreclosure activities would be less able to comply with the act than a more traditional debt collection agency. Again, they're using the excuse of, well, we just have too many foreclosures, we can't comply. Really? Finally, the court dismissed the Draper's argument that it was a debt collector only under certain provisions of the act, concluding that once a party meets the statutory definition of debt collector, it is subject to the act in its entirety. Again, let me clear that for you. You can't just say, I'm only part a debt collector. Once you've met the definition of a debt collector, all the act applies to you, and everything within that act you can violate. Does that make sense? So, with that being said, never let one of these trustees tell you, oh, we're not a debt collector. Remember the language within here. This is very, very important language, and I'm going to post it underneath. All this will be posted underneath here, plus we'll have the case itself so you can copy and paste it and use that language and argument in your own case, which is very important.